So a state appeals court ruled that the Second Amendment does not protect machine guns. Let's go ahead and talk about it. Hey Wolverines, I'm John Crump and this is John Crump News, your daily stop for gun rights news. Today we're going to be discussing a case out of Indiana dealing with machine guns and the Second Amendment. I have a feeling that most of you will not agree with the appeals court, but hey, what do I know? Before we get into the story, please like the video, subscribe to the channel, and comment down below what you think of this messed up situation. If you want to do a little bit more, we have a way you can do a little bit more. Head over to johncrump.locals.com and join up. Use code Wolverines for a free month. Now back to the case. It involves an 18-year-old named Jacob McGee, who the Indianapolis Metropolitan Police Department arrested for carrying a Glock 22 equipped with a Glock switch. I probably don't have to tell you what a Glock switch is, but there might be some people out there that's never heard of a Glock switch, so I'm going to break it down for them. If you know what it is, just stay tuned or leave comments down below with what you think of them. A Glock switch is what is known as a machine gun conversion device. You hear law enforcement refer to MCDs, and that is a machine gun conversion device. Federal law states that any device that converts a firearm into a machine gun in itself is a machine gun. That means MCDs such as Swift Links, drop-in auto-sears, lightning links, Glock switches, and any other number of MCDs are all considered machine guns under the National Firearms Act of 1934. Because of the Hughes Amendment that was attached to the Gun Owners Protection Act, no new machine guns can be registered for private ownership that were made after 1986. And since no Glock switches were produced before 1986, all of them are banned from private ownership. That means Mr. McGee's switch could not be legally owned. You might be wondering how these guys get these switches if they have never been legal. Some people make them or print them, but most switches used by gangbangers can be traced back to China. Buyers will buy a bulk shipment of switches from Chinese websites that are very sketchy and flip them to other gangbanger friends. I'm not saying McGee is a gangbanger. I have no evidence to say that. But I'm just letting you know how gangbangers get these cheap Chinese-made switches and resell them to other gangbangers. McGee was found guilty in a bench trial of a Class 5 felony, which is a serious felony. He appealed his conviction to the Court of Appeals for Indiana, claiming that the Second Amendment protects machine guns and the law banning machine guns is unconstitutional. On February 19th, a 3-judge panel ruled that machine guns are not protected by the Second Amendment and upheld his conviction. In Bruin, the first step of a Second Amendment challenge involves the original text of the Second Amendment. They claim that even though McGee was clearly part of the people, machine guns are not protected arms. So step 1 of Bruin failed. The 3-judge panel said since the conduct is not protected, the man's conviction must stand. And there was no reason to go to step 2 of the Bruin test, which is tradition and history of the nation's firearms regulations. The 3-judge panel went against the grain of recent cases dealing with criminal charges for owning machine guns. Remember, the only crime that McGee was convicted of was owning a machine gun conversion device. I am not a lawyer, but if I was his lawyer, I would say that we're going to take it to the state Supreme Court. If that failed, I would launch a Second Amendment protection challenge on the federal court level. Because let's break this down a little bit. It seems like the court came up with a decision first, then found a way to get there. If you look at Heller said that arms that are in common use cannot be banned. Now, how many machine guns are there in the country? 750,000 in private hands. If we compare that to stun guns, there's 250,000 stun guns in private hands. SCOTUS said that 250,000 stun guns constituted widespread use and constituted common use. So by using that logic, 750,000 is 3 times larger than 250,000, so therefore machine guns must be in common use.